So my name's Steve Allinson. I'm a lawyer here in Wallingford. My office is right on the corner of 68 and 150 in Yalesville. I do a few other things other than probate, but I'd say probably, 70, 80%, 60, 80% of my practice is probate. When I talk about probate courts do all types of things. It doesn't just mean decedent's estates or moving a will through probate or handling somebody's estate that doesn't have a will. There's conservatorships, there's guardianships for the intellectually disabled, there are name changes. Probate court also handles some family matters when it has to do with children and third-party custody. What I mean when I say third-party custody, I mean grandma and grandpa need to become the guardians, or aunt and uncle, somebody outside of mom and dad. Just a little bit of a disclaimer about today. We do a question and answer type of format here, and I've been doing these talks, I don't even know how many times I've done them now, but I do a lot of them, and I'm usually here about every other month. And when we do them, somebody will pose a question and I'll try to answer it as best as possible. But we try to keep it as general as possible. We don't want to talk specifics. Number one, you're in a group of people. Number two, we're being recorded today, so we want to keep it general and vague about an area of the law. So I can't give you specific legal advice in this type of a setting because it's not confidential. If you do need something specific or you have a specific question, please call me. I have cards and pens. Please grab one, reach out to me, say, hey, Steve, I saw your talk. Can you help me? Happy to do it in a much more confidential setting than here. That being said, we're going to try to touch on some major points of probate. The laws have become much more complicated. And unfortunately, the government doesn't do a great job of letting everybody know what the nuances are and how they work. And so that's what started me doing these talks. My next talk is going to be on October 30th here at 6:30, same place, same time. Every time I do them, these talks are different. You'll hear some of the same stuff, but it's always going to be something different. You're going to hear different stories, different examples, and learn about different areas of the law. So we cover everything from wills, powers of attorney, trusts, Title 19 or Medicaid. We talk about all of those things in this setting, and in an hour's amount of time, we just don't have the ability to get into or educate you to a point where you're going to be able to walk away an expert today. We're talking months and months of study, months and months of review of documents and what the law is and how it can apply to you. So hopefully today I can at least give everyone a little bit of an idea of how probate works, what vehicles, what tools you can use to make your plan better and be as successful as possible throughout the process. Sound good? All right, I'm going to try to be as light as I can in this subject matter. It is not a fun subject to talk about. In fact, a lot of folks won't even come here. So thank you for being brave and coming out and touching on the subject because it is really important and you can't avoid it. That being said, let's have some questions.
Is a trust part of the probate procedure?
Sometimes. So let me give you a little bit of information about trusts. So there are probably thousands of different types of trusts that are out there. There are two main kinds of trusts, okay? And before I get into that, let me tell you the basics about every trust. Every trust must have four things, okay? It must have the person that starts it, or the entity that starts it. A company can form a trust. A trust can form another trust. But you need to have somebody empowered to start it. That's generally called the grantor. The second piece is the trustee. That's the manager, the person who follows the rules of the trust document and does what the trust document's supposed to, tells them what to do, right? The third piece is the good piece to be on. That's the beneficiary. That's who gets whatever the trust is administrating, right? The stuff that's in the trust. And that brings us to the last piece. What is the trust made of? It's got to have stuff in it. And we call that corpus, Latin. Trust can have anything from cash to gold doubloons, cars, watches, guns, real estate, anything you could possibly think of that's an asset, pets, those can all be held by a trust. Now we divide them into two main types, and the terms for these are easily confused. There's revocable and irrevocable. So we did a really good job of making them sound very different. The revocable trust is the most common one that you'll see in the newspaper ads and maybe even on TV, or your friends will tell you that they went to a presentation about this living trust or this family living trust that they formed or wanted to form. And a lot of places that do this, they'll do presentations at hotels and other places that they can give you some free food and some information. What a revocable trust is it's a vehicle where the trustee, the initial trustee, and the initial beneficiary are generally the same person or group of people. What do I mean? I mean that the person in charge of doing what the trust says is also a person that can draw on the money. If you imagine a two-piece suit, like what I'm wearing, I can take money out of the pocket of my pants and put it into the jacket. I can say, in the same fashion, take money out of the jacket and put it into the pants. If the pants are my personal bank account and the jacket is the trust bank account, I can go back and forth as many times as I want, and that trust is a revocable trust that is taxed based on your tax ID number. So it's whatever your effective tax rate is. If that trust makes income, that's what you pay in taxes. Pretty straightforward, pretty simple.
Does an irrevocable trust have its own tax ID
We
separate?
haven't gotten to irrevocable trusts yet.
No, revocable, I'm sorry, revocable.
No, a revocable trust initially, when it's formed, is on your own tax ID number.
Okay.
So it's your asset. So what does that do? Well, it forms a separate entity. It forms a bubble around those assets. So if you had a rental property and you wanted to form Rental Property LLC to own that rental property, you could do that. Or if you wanted to form the Rental Property Trust to own the house, you could do that as well. Really doesn't give you any benefit as far as protection, whether it's in a company, an LLC, or in a trust. It's the same level of protection. It's not yours, it's the trust's. But if it's revocable, you can pull that property back out of the trust and put it back in as many times as you like. Best example is with a bank account, because you're going to draw some money out, you're going to put some money in, and if you need it, you can pull on the trust money. Pretty easy. What does that give you? It gives you protection from creditors. If somebody were to sue you individually, the trust assets are separate. In the example with rental property trust, if somebody were to slip and fall on the rental property trust's property, 123 Main Street or whatever you want to call it, there might be insurance, there might not be. But all they could do is sue the assets of that trust. They couldn't come after your personal assets. So there's that line that's drawn. What do you think is the exception to that rule? What creditor do you think it doesn't apply to? Uncle Sam, yeah, of course, of course. So let's say you haven't been paying your taxes and you put all of your money into this trust, the Jones Family Trust or whatever you want to call it. Okay, great. Uncle Sam's going to say, hey, you owe us money, and it's a revocable trust. You can reach in at any time you want to pull that money out, so pass. Reach in and pass. And you got to do it. The bigger problem, and this is where people get confused, is Title 19, Medicaid, skilled nursing care, right? A revocable living trust will not protect you from the government. If you want to qualify for Title 19 skilled nursing care, you need to have less than $1,600 of assets. And the state of Connecticut is going to tell you, if you have a revocable living trust, plus your individual assets that are more than $1,600, you're not eligible. Pull the money out of the trust and pay for your care. A revocable trust, excuse me, I get caught up in the terms as well. An irrevocable trust is much different. One person has the jacket, the other person has the pants. The jacket is the trustee, the pants is the beneficiary. So the beneficiary can't reach into somebody else's jacket to take money out on their own free will. If they can, under the terms of the trust, then it's not irrevocable. So, it's the job of the trustee of that irrevocable trust to reach into that pocket and pay money out. That does give you protection from Uncle Sam, also from the state of Connecticut. Also creates a bubble of insulation for liability and everything else. Same rules apply. The difference is how it's set up. You can set up an irrevocable trust to do several things. And I'll give you a couple common examples. One common example is I am going to form the Allinson Family Trust, and I'm going to make my son the beneficiary, and I'm going to be the trustee. Okay. I put money into the trust. I can pay it out to my son. Who can't I pay? Me. I can't take money out to do that. So commonly, for estate planning purposes, we'd flip the roles. The son's the trustee. I'm the beneficiary. Now he can reach into the trust and give me money. And generally the language that's done in there is at his sole discretion. So whenever the trustee feels it's appropriate to give me money, he can reach into that trust and pay it out to me. Here's the problem. If I'm on Title 19 and he reaches into the trust, a separate entity, and gives me money, and that money puts me over that $1,600 limit, well, guess what? I'm over assets. I lose my benefits. So, bigger problem is, what happens if I need money and he won't give it to me? I can't force him to do that. In common estate planning, in that situation, most people say, hey, at my son's discretion, he's going to pay out the money to me, and then when I pass away, all of the money is going to go to my children equally, or if my son's my only child, to my son completely, right? So he doesn't really have much interest, financial interest, in paying me money, because when I die, he's getting everything, right? Another way to do it is you can set up a trust rule where it creates an annuity. The trustee has to pay. So my son now has to give me $1,000 a month, $5,000 a month, 50 cents a month, whatever it is. What's going to happen? The state of Connecticut is going to come in and say that's a stream of income. You need to divert it to us when I'm in that nursing home. So it will never come to me. It will go to the state of Connecticut, because they have first right to divert that income. So depending on what you're trying to do for planning and how you're trying to do things, depends on which trust you're going to want to choose. One other thing to think about with the two different types of trusts. A revocable trust, when you put money in, it does not create a gift tax liability. An irrevocable trust, because you can't take it out, and an irrevocable trust has its own tax ID number, that is its own entity. So if I give more than $14,500, or I think it's $15,000 this year, $15,000, whatever the yearly gift tax liability limit is, if I give that to the trust, or if I give more than that to the trust, then guess what? I have to file a gift tax return. Gift tax is paid by the giver. Now, there are lifetime exceptions and lifetime limits where you can give more than $15,000 at a clip to an individual, but you have to file a return. And it has to go through the IRS. If you don't do that, feds are coming after you, right? So there's a lot of different concerns and a lot of different pieces. Is a trust right for you? I don't know. It depends. If you go into Home Depot because you have a box of screws at home and you bring a saw up to the register, they'll sell you a saw. It's not going to help you a lick with the box of screws though, right? So if you go into a lawyer's office or you go to a presentation where they're talking about the trusts that you need and you say, yeah, I think I need that, great. But if you're doing it because you haven't really gone through exactly what your personal situation is, if you don't look at those things, you're not going to be buying the right thing. You're going to be buying that saw, except the return policy is a lot different than at Home Depot, because once you buy the trust, you've gotten what you've asked for, but it may not be right for you. So you want to pick the right tools for your situation. How do you do that? What are your kids like, right? Are they good with money? Can you trust them? Do any of them have special needs? Do any of them collect disability? Do any of them have any prison time? Do any of them have drug problems? All of these things are different considerations that everyone's family is very different, and they may have. And if you have those situations, it may make sense for you to form a trust. One of the two major types will probably suit your needs, but if you have good kids that you can trust, that you don't have to worry about financially on those ends, you may not need a trust. You may be adding more protection than you may actually need. So what do? You pick up your phone, you call a lawyer that you trust, somebody that you can talk to about your family situation, and you say, hey, this is what my family looks like. Tell me what I need. This is what my assets look like. Tell me what I need, right? If you've got an $80,000 bank account and that's your entire amount of assets, and you've got 4 kids or 5 kids, and you're 50 years old and you just retired early, it may not make sense for you to have a trust. It might, but it might not. So you got to really play around with what does your individual picture look like. And that's what I try to do. I try to look at everyone's individual situation and try and fit the best tool for the job.
Now, when you use the term protection, are you saying protection from possible government taxes and fees, or protection from the assets going through probate?
So any of the trusts that you form during your lifetime, that are funded during your lifetime, pass outside of probate. That does not mean that you're not subject to fees on them, but they pass outside of probate, meaning probate court does not have the jurisdiction to tell the trustee how to administer those assets. So when I say protection, it's protection from a few things. It's protection from potential government liens or government seizure of your assets due to debts that may accumulate. It's protection more from a nefarious family member, the bad guy, right? We've all heard stories about somebody that had, a niece, nephew, child that took somebody for a ride. And those situations are where you can have a lot of protection by using a trust. You can have a lot of rules in place as far as how that's administered. Let me explain to you a little bit about the probate fees, because that's a good question and a good point to bring up. So when you go through probate, there's a few different ways that you can go through probate. There's one process called tax purposes only. That means there are no assets that fall under probate jurisdiction, and it's just to file an estate tax return. In Connecticut, there is a form called the CT 706, NT, which is a non-taxable report that needs to be filed in every probate matter. The second type of probate is what's called a small estate or an affidavit estate. And what that is that's for an estate that has less than $40,000 of solely owned assets. So if an individual has only their name on the bank account, the only way to move that to beneficiaries, whether or not there's a will, is to go through probate. The last type is a full estate. It's for anything that's more than $40,000 of total assets, of solely owned assets. So if you imagine you took a bunch of index cards and you wrote every asset you had on the table, and I don't mean like dish towels, I mean bank accounts, cars, houses, stuff that has, you know, some sort of real intrinsic value. And you put down how they're owned. Me and my wife. That's technically survivorship. So when I die, that automatically passes to my wife outside of probate, meaning probate court does not have to issue an order to have it passed to my wife. Real estate's a little bit different, and I'll come to that in a second. But in all of these probate matters, you need to file that CT 706 NT or taxable. In Connecticut, the estate tax limit where you start paying estate tax is now 3.6 million. Federally, I believe it's over 11 million. And I think it's climbing to about 13, but don't take those numbers for anything, you know. I gotta look them up. But if you're under that 3.6, you don't have to file federally, and all you have to file in Connecticut is the non-taxable form. And that's required of anybody that passes away, to file that form with probate. When you fill out that form takes into account solely owned assets, jointly held assets, assets that might have been in your lifetime in a revocable trust. Because remember, that revocable trust you can tap into at any time. At your passing, it becomes irrevocable. But because it was during your lifetime, those assets are includable in your gross taxable estate. When you add all of that stuff up, if it's less than 3.6, you don't have to pay taxes. But you still have to pay something, because guess how the probate fee is figured out? Not by the stuff that probate court can control, but by your gross taxable estate. So the government looks at everything that you could have had access to during your lifetime at the time of your death, and says, based on that, the probate fee is a percentage, and it's a sliding scale that graduates depending on the amount of the estate, all the way up to that 3.6. And then when it's over 3.6, there's a tax that issues from the feds. But the probate court goes up to God knows how much money somebody could have. There is no cap on it anymore. There used to be, but it's gone. So that's kind of how the taxable piece and the tax form files. So there is no real benefit if you do a will, you do a revocable trust. Am I saving on probate fees? No. If you gift all of your money to your kids during your lifetime and you have nothing, are you saving on probate fees? Yes, because you have nothing at the time of your death. If you gifted all of your money to an irrevocable trust, you still have nothing at the time of your death. So that changes the picture. That changes the scenario of what you're looking at the time. But what happens once you give something?
Get it back.
Can't get it back. Can't get it back. And that's the risk reward that we try and manage in doing these types of planning.
If the estate has no assets, do you still have to file this CT 706?
If the estate has no assets, do you still need to file a CT 706? Technically, yes. Okay? Technically, everyone at their passing somebody has to file a CT 706 for them. have I ever heard of anyone knocking on somebody's door saying, you didn't file a CT 706 for, the guy that used to, ask for change outside of the movie theater? No, I haven't heard that. But have I heard the state of Connecticut coming down on folks that have transferred money or had not filed the CT 706 or not gone through probate? Absolutely. And so if there is a skirting of the system, there's liability there. And that's the word we call fraud, which we really want to avoid. Because fraud not only has criminal problems as well as civil, but on the civil side of things, there can be additional damages. So if you committed fraud to the tune of $1,000, your debt is going to be significantly more than that $1,000. So that's the hammer that can get dropped to be careful about. I want to talk about real estate real quick. If the only asset you have is real estate at the time of your passing, and that's in survivorship, it's pretty easy, right? If me and my wife own the house together, the house automatically passes to her at the time of my death. Under the law, that works just fine. The problem is, nobody is going to buy the house when my wife wants to sell it after I kick the bucket, They're going to want to make sure that they have clear title. What's the problem? If the probate court has not issued that release of estate tax lien, which gets filed on the land records, and clearance to say, hey, you know what, we don't know, or to show that there's clearance to say, hey, we know for certain there is no estate tax due, what can happen? The state of Connecticut can come back in and say, hey, we're going to reopen Steve's estate so that we can get paid. So if you're buying a new house from a couple where one of them has passed away, that title search doesn't have clearance from my estate when you're buying it from my wife, guess what's going to have to happen? Closing is going to get delayed until probate is filed and that clearance is filed with the land records as proof that there is no estate tax lien or estate tax owed to the state of Connecticut.
But that's something your attorney should know. It's not like we have to walk in and say that.
No, but it's something that you should think about if you know that you have a piece of real estate that's owned between you and somebody else and in survivorship and one of you passes away, you should definitely know that you need to file probate for that other person. Otherwise, at the time of closing, you may have somebody that says, yeah, we're going to close, time is of the essence, we need to close 60 days from now. The chances of getting that release of estate tax lien in 60 days is very, very slim, and that closing could fall through. And you may not get as good of an offer from somebody else as you have from that current buyer. So by staying on top of it and filing with probate, you know that you've cleared the title so that when the closing does happen, they're still going to do a title search. And if anyone's buying property, the title search is going to be done on the other end. But you want to make sure your assets are protected so that when it comes time for you to sell your property, you don't risk losing a good deal.
So the way I'm understanding it is, husband and wife, husband dies. You need to file with probate to clear the husband's name off of the title, but the title will remain in the wife's name at that point. So she'll have clear title to sell further down the road. Am I understanding that right?
Yeah. So the question is that when a husband and wife, when one of the two passes away, the survivor needs to go through probate, even if all of the assets pass outside of probate, to get that clearance of that estate tax lien.
Okay.
Because there's an automatic estate tax lien on any property when somebody passes away, and that has to be cleared before the property can transfer.
Is there a
time for when somebody dies that they have to go to probate?
Short answer is no. Long answer, the time when you have to go through probate is as soon as possible. And the reason I say as soon as possible is because it's required that you file that estate tax form within 6 months of the person passing. Otherwise, it accrues interest. So to avoid interest on that, you do it within 6 months. Can it be done years later? Absolutely. But there's a charge for it. So you can get, we're not talking a ton of money. We're talking, a few percent. But still, it's money that you wouldn't have had to pay if you stay on it fairly quick.
If there's tangible assets and someone dies without a will, nobody grabs the ball, takes it to probate, and then many years later, people in the family want to sell those assets. Can the beneficiaries be liable for any of the taxes and fees and whatnot?
So it's a little, the question's a little vague. If somebody dies and they have assets like a car or a house or a bank account and probate has not been filed, at the time that probate is filed, it's absolutely possible that the individuals that received funds could be liable for that estate, that probate fee to do that. If somebody passes away with nothing other than some dish towels, household furnishings, toothbrush, some sneakers, and maybe a set of weights that you might be able to get $50 for on on the flea market, the state of Connecticut's not really looking at those things. Could they? Yes. Would they? It's not really worth their time to dig into those things. The bigger problem with tangible assets is really when we're talking about collectibles, stamp collections, coin collections, baseball card collections. And if those aren't valued or reported properly, then there could be some significant implications. If somebody's got a Mickey Mantle rookie card sitting in their baseball collection, it's going to be a lot different than if, all they have is, a Derek Jeter card, which there are thousands of, and they're, despite being a great ball player, they're not worth very much, So it really just depends. Coin collections are really interesting because they go from the same end of the spectrum, that cool Derek Jeter card that isn't really worth anything, to that Mickey Mantle rookie or beyond, because they're coins. They've got a face value on them, but they also have a collector's value. So depending on what it is going to really make the difference. What I
How would
recommend.
somebody know that you didn't own them yourself?
Well, it depends.
I mean, it could be, a coin collection or a stamp collection.
Well, I can't stand here. I can't stand here today and tell you to.
No, I'm just saying though, that I wouldn't think that would be beyond someone's thought.
Generally there are receipts for purchase. So when you're purchasing, a rare Morgan silver dollar, for example, there's generally a transaction that occurs with a receipt and a certificate of ownership that will pass with those things. Some things there isn't. I mean, at one point I had a He-Man action figure that might be worth something now. I don't know. But is there a title to that? No. And the issue is what's reported and what's not. So if it's reported in probate, there's a couple ways to go about it. If it's reported as an heirloom, so it's, mom's diamond necklace that has, a very small stone on it, it's not worth very much, generally there's not really an issue. But if it's a large stone or worth something, you run the risk of somebody saying, hey, that diamond necklace was never appraised. We don't know the value of it. So without that appraisal, it's kind of hard to be able to say you're free and clear to grab the jewelry box. You know what I mean? And the bigger problem is when there's multiple beneficiaries, because everybody wants to get their fair share. And if something's not appraised, how do you know you're getting your fair share? And there's a difference. When I say appraisal, there's a difference between what the appraised value is and what its street value is, right? So if I were to sell a diamond necklace to a jewelry store, they may pay me 50 to 60% of what it's actually worth or what they're going to resell it for, right? It's not replacement value, it's what is it worth? How do I turn it into cash? So that's the actual value of the item. How about another question?
In a real estate listing, when it says sale is subject to probate, what does that mean?
That generally means that the owner of the property had passed away. And it means that, or that they have a conservatorship, and so that person's conserved. What it means is that the probate court has to review the appraisal of the property, the contract for the property, and the sales price, and say, yes, this is fair, which usually takes, from start to finish, about 3 weeks, 3 to 4 weeks to get that approval. It's a little bit of a delay, but all it means is the probate court is protecting the seller to make sure that the seller is getting a fair deal, that it's an arm's length transaction. You know, nobody's trying to cut somebody short here.
Yeah.
How about another question?
How about wills?
So a will is very interesting because it's different than a trust. So a will is a set of instructions, right? And a will is a set of instructions that tells an executor how to handle assets. Pretty simple, pretty straightforward. You can have a lot of different things in your will. You can talk about guardianship of children. You can talk about all sorts of conditions that you may want. But at the time of your passing, those conditions must be met. And I'll give you an example. If your will says, at the time of my death, any of my children that have attained a bachelor's degree or higher shall get an extra $5,000 more than those children that did not. Now, if all the kids have the bachelor's degree, doesn't matter, right? Because it's fair, it's all across the board. But let's say there's 2 kids, one has one doesn't. At the time of your death, we know there's either a bachelor's degree or there's not. It's a light switch. It's on or it's off. No dimmer. So you know exactly what's going to happen. With a trust, you can do something different. You can say, if that person during their lifetime gets the bachelor's degree. Because if in your will, you say during their lifetime, at the time of your death, they're still alive. So there's no way to determine whether that light switch is on or off. So that said, the restrictions and the terms that are in your will need to be spelled out very, very clear and precise for exactly what you want.
But should that also be in trust?
Well, a will and a trust are 2 different things.
Yeah, I
So-
understand
so-
that, but both of them, don't they, since they're a legal document, they have to be precise?
So it depends. So if the term was during that child's lifetime, the probate court may decide to take a $5,000 number and put it into what's called a testamentary trust, a trust that is formed by the court by virtue of your will, because they can't determine whether or not that term has come up. And they need to close out the probate estate. So the estate will close, that trust with that amount of escrow will be held in it separately until the time that person either gets a bachelor's degree or passes away. or the funds of it are depleted, which in the $5,000 example, it's not going to last very long with administrative costs and fees. It's going to weed out pretty quick. But I mean, you get the point. You know, you can do it with 500,000 or whatever the number you want to do. But in your will, those terms need to be exact. And in order for your will to take effect, a will requires that you know what you're signing, and there are 2 witnesses that sign it. Does not require a notary. Should it have a notary? Yeah. Why? Because the notary takes the oath of the witnesses to say that they witnessed you being of sound mind and you signed the will yourself. So what happens is during a will contest, the first thing people ask is, did that person sign the will? If there's that affidavit attached to the will that says, yes, they did, and we took the oath of the witnesses, those witnesses do not need to be present at court to be able to testify that they saw the signing of the document, which is very helpful, especially if the witnesses happen to be a little on the older side and may have passed away before you. So that kind of makes the document a little bit more close-knit. The big problem in most will contests are generally filed on what we call capacity. Did you know what you were signing? Were you under the influence of drugs, alcohol, an illness, or maybe some undue influence? Did somebody threaten you that if you don't fill out this document, X or Y or Z is going to happen? In that case, the will is invalid. But that needs to be proved to the court. So the court has a process for admitting a will to probate, where all of the beneficiaries under the will and all of the beneficiaries under the law are all notified. And they...
Isn't it true that you have to, so somebody doesn't contest the will, you have to leave them a small amount of money?
I don't understand the question.
When you do a will, and it gets, so it won't get contested, like you're saying, don't you, you don't want it to get contested by, let's say, a person A, you have to leave them a little bit of money, just to, like, kind of...
Anybody can contest a will at any time. So as long...
Even if they're not in the will?
If they're they have to be either a beneficiary under the will or a beneficiary under the law. So if I wanted to write a will that left my kids and my sister all of my stuff and my wife nothing because I didn't like what she was cooking for me or something, right? You know, I could write that will, but my wife could contest it. Even though she's not in the will, she's a beneficiary under the law. And if that will is not admitted to probate, she has a right to take. So the legal process is that all of the beneficiaries under the law and all of the beneficiaries under the will get notice. Now, if none of them object, and none of them file anything saying, hey, we don't object to the admittance of this will, the will gets admitted. And now that will becomes a legal set of instructions on how to move forward. But until that point, there are no instructions, and nothing can happen. A lot of times in will contests, the court will appoint a temporary administrator whose job it is to marshal all of the assets, put everything from that person's name into the name of the estate and secure them. And then they sit and wait until the will contest is litigated and there's a result that comes out in an order of the probate court. Sometimes it can be really complicated. Somebody has a house that has taxes due on it, and they've got back water and sewer, and maybe there's a credit card lien on it, and that house is just losing money and losing money. That temporary administrator is very valuable in that situation because they can ask the probate court for permission to sell the property. If the probate court grants that permission to sell the property, Then they go to an agent, and the agent will list, subject to probate court approval on that listing, and it will go up for sale. And then they can stop the bleeding of financial bleeding, that's there. So it depends on the process and depends on the situation. If you leave somebody $1 or $0 or $10, it doesn't really matter as far as what the probate court's going to decide or what rights that person has, though. The only time I can tell you that you will have written a document that will be almost infallible is if your will mirrors very similar to the state law, if not exactly what the state law says, or if you're the surviving spouse and you've written it equally to all of the children and they get an equal percentage. If your will doesn't say that, that doesn't mean it's not enforceable. It just means that there's a chance that the person who's written out of the will or written for getting a lesser share is going to be upset and may look to file a will contest. The way to combat that is to meet with a doctor very close to your signing of the will, to do it when you're of a younger age, which we can't roll back time, so that's not something that we can really fight too much, or if you do multiple wills. I had a very interesting case, and this individual did about 15 wills, okay? And the thing is they all said something different. The beneficiary I was representing was getting the same thing in every one of the wills, every single will. But the rest of the stuff was done differently with his other siblings. Okay, that's fine. The problem is, if I file a will contest on will 15, what happens if I win? It rolls back to 14. It rolls back to 13. It rolls back to 12. And the idea of showing that somebody that has, advanced dementia didn't know what they were doing, going back over a 25-year period to be able to get rid of 15 wills is a sheer impossibility. It's just not able to be done. I recommend about every 5 years, 3 to 5 years, depending on your age, to review your wills and your estate planning documents and to update them, because it gives you that buffer, especially if your kids or your beneficiaries are not getting equal shares. That's a very big red flag to do them more often. If you don't have that situation, you still want to look at them about every 3 to 5 years and make sure that there aren't any problems. The laws change. Recently, our power of attorney law changed, I think last year or the year before. So there are updates and other things that we want to work on. As tax laws change, there may be benefits for spouses, for children, for special needs relatives that you can work into these documents to make them work better for you. And you can get those benefits by regularly updating.
What was the change in the power of attorney?
So the Power of Attorney Act changed from having a statutory form previously that did not require certain things from financial institutions to a uniform Power of Attorney Act. So our act mirrors acts of other states. And what that does is that tells the bank, and that law tells all banks or all financial institutions, that any power of attorney that's validly executed needs to be given full faith and credit. The bank has the opportunity to ask for an affidavit from an attorney to say, yes, this power of attorney is still in effect. But that's the only piece that can be done. The other piece that was added was a successor power of attorney. In your power of attorney, it used to be set up where you named somebody and that was the person. And if you had a successor, the banks would usually say, hey, wait a minute, how do I know that the first person isn't there? They can still do that, but they can do that only through the affidavit process. So the liability has transferred from being solely on the bank to the bank saying, hey, we want an attorney's certification to certify that this is still valid, and maybe number 2 power of attorney is the right person. So those were the 2 major changes. There were a couple other changes in the language, but it's not anything big. If the power of attorney that anyone has is older than 96 or so, then you should probably update it. If it's older than 2005, 2006, you should probably have it reviewed at least. Most financial institutions, if it's less than 5 years old, won't make anybody go get the affidavit. They're usually pretty good with it. If it's older than 5 years, they tend to ask, but it's up to the bank. It's their discretion, really, on that piece. Our law used to have healthcare decisions to allow those in powers of attorneys. That's no longer the case. And so if you're looking at a power of attorney that's over 10 years old, check and see, does it say healthcare decisions on it? If it does, you should redo your power of attorney and do a living will or a designation of healthcare agent so that they're in separate documents. Because otherwise, at the time they're needed, there might be a bit of confusion. There may be an argument over, is the document valid? And those delays are not ones that you really want to play with. Because remember, power of attorney gives somebody the immediate ability to handle financial affairs. A designation of a healthcare representative or a living will gives somebody the ability to make healthcare decisions when you are not able. At the time you're not able, you may need a decision made, and you don't want that document being argued over. So you want to make sure that the documents are clearly laid out and separated, which was, I want to say, probably about 15 years ago that that change happened with the healthcare piece. But don't quote me on that.
If you've been assigned, or to negotiate power of attorney with another member of your family, and that family member dies, does your power of attorney die with them?
Powers of attorney only last during the lifetime of the person that signed the power of attorney. So if I gave you power of attorney and you ran down to the bank right now, and as soon as you stepped out of the door of the library, I died, not valid. In that example, you might have what we call the innocent person, right? You didn't know, right? And depends on what you did. If you went down to the bank to take the money out and put it in your pocket, well, that now makes you a bad guy. But if you went down to the bank to take out some money to go pay the taxes on the house because you didn't want to see me incur any more, penalties, late fees, or interest, well, guess what? You're being a good guy. So no harm, no foul. But that power of attorney stops at the time of death. So you really can't use it, but you don't have to, go down to the bank and make a phone call to the individual. Hey, you still with us? You don't need to do that, But again, our Fiduciary Powers Act gives a lot of powers to powers of attorney, to conservators, to trustees, to executors, but it also puts a lot of liability on them as well. As long as you do things right and follow the rules, no problems. The second you step out of that or want to do something creative, it may be that creative is okay. But you should go down either, if it's a conservatorship, a trust, a will that you're working with, or an estate that you're working with, you should go down to the court. Get the court's permission. Get the court to say, hey, this is okay. Now you've got a court order that says it's okay. And now you know your creative plan is A-okay. And if the court says no, then they say no. And you have the answer. I had a case where somebody wanted to take a loan from their mother who is doing Title 19 planning. And so she has a limited amount of assets, but those assets are being spent down. This guy wanted to take a loan out from her. Okay. What are the terms of the loan? Does it make sense? Is it viable? The right thing to do is to go to all of the beneficiaries, have a family meeting, and see what they say. If all of the beneficiaries don't agree, then guess what? It shouldn't happen. Because mom's still with us, there's a power of attorney handling the paperwork and handling the assets, and you get requested to do a loan, and guess what? Who is the person that can sue that power of attorney? The beneficiaries, because they have a right under the will or under the law as heirs of her eventual estate. So you want to be careful about doing those things. Conservatorships and will and estates and trusts are administered in a way that we can really watch them through the court. And anytime there's ever a question about, is this the right thing to do? I say, go to the court, ask the judge, put everything on the table, be transparent. And my message through all of these talks that I give is about transparency. Not just to the court, not just to the government, but to your families. So if you do documents, or you want to do a plan, maybe you want to cut somebody out, maybe you want to give unequal shares, have a family discussion. Tell them. Say, hey, look, this is the plan, this is why it's this way, this is what I want, and I'm sorry if you don't like it, but I want you to hear it from me, not from your siblings after I pass. And it's a hard conversation to have, I know it is. But if you do that, the chances of them coming back and saying, my brother is doing this to me, is a lot less likely. So getting through that talk is one of the best things you can do. Last question for the night.
What is the look-back period for Title 19 on transferring your house to someone?
That depends. So the general look back for Title 19 is 5 years. So any transfer has a 5-year look back. With your house, it's a little bit different. Between spouses, you can transfer your house at any time.
What about children?
If you have a special needs child, you can transfer your house to them at any time without penalty. The only way to transfer to your children within that 5-year look back is if one or more of those kids have lived with you for the past 2 years and they've prevented you from needing skilled nursing care. They've prevented you from needing the state to come in to pay for your bill. And that's done through getting medical records and affidavits to prove that that was the case. It's a little bit of a cumbersome process, so I recommend trying to transfer well beyond that 5-year look back ever comes in. But if you have to get to that point, it is possible to do. Now, if you have a niece who's a lovely niece that lives with you for 2 years and kept you from going into a nursing home, she can't get the house unless it's beyond that 5 years. She's not a child. The rule is very, very specific. I'm sure you folks are going to have more questions. Come back and see me October 30th. Every one of these talks is very different. I've got cards and pens. You're welcome to call me at any time or shoot me an email. Happy to answer any questions that you have. Thank you folks so much for coming out tonight. You know, it's wonderful having everybody here.